Hello, my name is Dustin Hood. Thank you for coming to our site. We wish you welcome. You're here primarily because you're seeking information about bankruptcy. I will do the best that I can to give you some information about bankruptcy, but first a couple of caveats and warnings. The first one is one, I am not an attorney. I am not allowed to practice law. Two, I'm not currently employed by an attorney, and I happen to be in California at the moment. So I can't really call myself a paralegal unless I'm working directly for an attorney. Three, what I can do is prepare your paperwork to make sure that you have a successful filing in simple cases, primarily of Chapter 7. I'm going to express a personal opinion here. 99% of the cases that are very simple Chapter 7s do not require the assistance of an attorney. However, you are always best served by going to an attorney, and if you have a complicated case or if you feel ill at ease in any situation or at any time about representing yourself in a bankruptcy court, I absolutely urge that you seek counsel of an attorney. All right, let's start off with a little bit of information about bankruptcy and the bankruptcy process. Bankruptcy itself is part of the Constitution where essentially Congress is allowed to regulate the bankruptcy courts. How that's happened is through our court system from the Supreme Court on down to the local district courts, and in the local districts there are there are districts for bankruptcy. I happen to be in a district called the Eastern District of California. In California there are several. There's Southern District, Central District, Eastern District, and Northern District. There are more than 88, I think about 90. I haven't really checked the number of bankruptcy courts across the country lately, but it's a significant number, and you have coverage for bankruptcy anywhere in this country and its possessions, its outlying territories, etc. The process itself is fairly simple. Essentially, you're filing a petition with support schedules and declarations, all under penalty of perjury, making those representations to the court, to your creditors, and you're declaring essentially that you are bankrupt. You have no assets with which to, no current assets with which to maintain your bills. In a Chapter 7, and there are several chapters of bankruptcy, but in a Chapter 7, the primary goal is to seek rapid relief and a discharge of those debts which are dischargeable. I'm not going to go into what can or cannot be discharged, but vastly, the majority of your debts can be discharged with certain exceptions. Those exceptions have to deal with whether or not you made fraudulent applications for credit, etc. Most people don't do that. Most people just fall into a debt trap and get into trouble. That's what the bankruptcy court is for. The bankruptcy court is to help you get out of that trouble and start back onto a path of leading a normal life. In my opinion, you've got a few different obligations. The first one, of course, is food. Second, clothing. Third, shelter. That includes for you and your family. Medical care, of course, would be included in that area. Your taxes to your government, and if you have some obligation to your churches, that's probably a good one there. Beyond that, everything else is pretty much a luxury. Paying your creditors sometimes can be a luxury if you're definitely taking away from any of those other categories I just mentioned. So if you're doing without food, or your shelter is imperiled, your family's health and welfare is imperiled, you are definitely a candidate for bankruptcy. Let's talk about the bankruptcy itself. The process, as I said, essentially you file a petition with support declarations and schedules. What you're doing in that process is establishing a bankruptcy estate. What you're saying is, here are all of the things that I owe to all of the amounts of money that I owe to people or companies, and this would include your family if you've taken a loan from them, or your credit cards, or your house payment, your car payment. Some of those debts will be secured. For instance, if you could be foreclosed against on your house or possibly lose your car, because you didn't make a payment, those would be considered secured loans, and many of them are unsecured loans. Generally, those unsecured loans fall into the categories of credit cards and whatnot. Visa, MasterCard, American Express, Discover, those types of people. There are other types of obligations you may have, such as leases, instances where you may have co-signed for other people. All of those things add up to an obligation by you or to somebody else to perform something that's either in the payment of money or some other thing. Bankruptcy helps to dissolve those issues, helps to get rid of your obligation under those issues, and to be discharged and walk away from them free. The process of filing your petition and whatnot creates what is called the bankruptcy estate. And once you have listed all of your assets, which of course would include, for instance, your home if you are buying it or if you own it free and clear, your automobiles, your any kind of tangible property, if you think about it, and any kind of intellectual property or any other type of property of any kind. This would include stocks and bonds, bank accounts, etc. All of those things are grouped into schedules for assets. In California and elsewhere, there are exemptions. In fact, all over the country, there are exemptions that can be applied to certain items. Some can be very liberal. Mostly, they're pretty much homogenous across the country. California happens to be one of those exceptional cases where, for instance, you may have the option to file in some states a state exemption table only. Possibly in another state you might have the possibility of filing for a federal and or a state, optionally, either one, exemption table. In California, somehow we've elected to take our state exemption table and then induct the federal exemption table as a secondary set of California exemptions. So we're sort of the oddball out. In creating your bankruptcy estate, we have to list those assets, and primarily we have to come up with some kind of value. Value on the assets, depending if it's not an asset which has a readily available liquidation value. For instance, you can pretty much evaluate that your house has a certain value. You may owe X number of dollars against it. You may have equity over and above that. In California and elsewhere, there would be a certain exemption if your equity was higher than how much you owed. And you would be able to, for instance, say, I can keep this if I keep the underlying obligation current, or it can be, I can elect to have it sold out and taken, but because I have declared a certain amount exempt, then I'm going to get that money back. This also happens with automobiles and whatnot. Your clothing, your furniture, your jewelry, you have certain exemptions all over. When you have a situation where your exemption value is not easily calculable. For instance, your clothing, who's going to buy your clothing at what you paid for it, or your jewelry, or your household effects. When you start to evaluate these, you think in terms of liquidation value, and liquidation value in this case often turns out to be what you would be able to get if you put it in a yard sale, and how much you might expect to reap from that yard sale. Many times, about 10% of the original purchase price is what's declared. Most of your household goods and whatnot have very liberal exemptions. Not necessarily a thing that you're going to lose in a bankruptcy, unless, of course, you elect to, for instance, if you have a secured asset, you just bought a new suite of furniture from somebody, and you owe on a secured basis against it. Well, there are some things that happened there. We won't get into them at the moment, but there are some things to look at. So you could certainly redeem them, or you could do a number of other things. If the value is so low that upon purchase, the minute you purchase it, drops in value 90%, you might elect to have somebody come back and take that from you because you don't want to deal with it. You don't want to deal with the payments any further, or there are some special court procedures which I would suggest that you go through and talk to an attorney about, because it's not something we can do. On the other side, after your exemptions are pulled out of your net equity on your bankruptcy estate, anything that goes over and above that net equity in the estate belongs to your creditors. In fact, in a simple Chapter 7, 99% of the time there's no equity over and above the exemption values. Rarely have I ever seen anybody come back and take an item just because the exemption had been exceeded. So this is not something you really have to worry about unless you've just got, if you have a Matisse or a Van Gogh, you might have a problem, but for the most part, it's not something for you to worry about. On filing your petition, we mentioned the bankruptcy estate. Well, that's actually a trust estate. And when you file your petition, all of your assets, your bankruptcy estate, starts to vest in the name of the bankruptcy trustee. That is the actual person or entity that is control of that property during the interim of your bankruptcy filing and your bankruptcy case. After that has happened, within I think it's 45 days, you will be assigned a date to go to what's called a 341A meeting. That's a meeting of creditors. I can tell you that that's a procedure that's mandated by law. You will certainly meet your trustee there. You'll be sworn in at the trustees meeting. You'll have a very brief examination. If your documents are in order, that will be a very brief examination. Basically, hello, I'm such and so. I do solemnly swear the following. Did you file this? Did you file that? How did you arrive at a value of this? Okay, that's it. That's done. We're done. Go have a life. At which point, your case should proceed to discharge with no further issues. Now, that doesn't mean that there won't be further issues, depending on what you have to say in your filing, but most of the time, that is not going to be the case. It's just that easy. You walk into the trustee's office, you walk into the trustee's meeting, you are sworn in, you're examined very briefly. Very rarely do creditors show up to the creditors' meeting. In fact, the trustee is appointed as the representative of your creditors. That's what he does. His assignment is to try and collect money from you based on any overage that you may have in equity over and above your exemptions. Again, I've mentioned that rarely happens, but it does happen occasionally, and the trustees are paid a basic fee for every case by the courts, but they're also paid an additional 10% of everything that they collect on behalf of your creditors. So, they have their vested interests. Once you have gotten past the 341 meeting, you are basically going to, within a very short period of time, receive a discharge. And at that point, once you've received your discharge, you are free and clear of those creditors. You no longer have an obligation to them. In fact, if they ever contact you again in reference to any of these debts, unless you've done something like reaffirm a debt, then you've definitely got a cause for action. Go run to an attorney, because he or she will be happy to sue your creditor on your behalf for violation of the discharge. Getting back to, by the way, when you file that petition, the automatic stay issued by the clerk of the bankruptcy court, but in the judge's name, the stay stays execution of all collection activities, and that's both equitable and legal. They can no longer contact you. If there's a suit pending, it stops flat. If they violate that, that's a whole nother action for you to go see an attorney and see if you can have them penalized for it. That doesn't happen very often. Most of the companies that do this are very aware of the problems. In fact, some companies have been massively penalized for various what can I say, violations of the bankruptcy code, and maybe, just to show you, up to $600 million. So they really don't want to mess too much around with it. Um, I suggest at this point that there are some things that need to go into your documentary package that need to be forwarded